Hi, very good afternoon to all of you. Thank you so much for joining us to this webinar. The webinar is Preventing Sexual Harassment at Workplace. I'm sure all of you will appreciate the topic why Paybooks has chosen today. This is because of late the entire corporate world is forced to have this policy in every organization and to have a defined and clear policy to ensure that there is a policy to prevent sexual harassment at workplace. So we have Mr. Tulsi Krishna, who is who is associated with Paybooks from a long time, and he's a well-noted advocate and a chief advisor. He is running an organization basically to the labor law compliance and HR-related training called HR Edify and Solution. He is a lawyer by qualification and also has was in a practice for a pretty long time, and now currently running HR Edify and giving consulting advice to many organizations in Bangalore and outside Bangalore as well. And some of his achievements were like wage negotiations and settlements with state unions, and assessed manpower requirement using zero-based manpower planning, and also like enhanced productivity and performance through hormone-based industrial relations, and conducted specialized training on industrial relations and labor legislation, associated with various education institutions for teaching on HR and IR, industrial relations and labor laws. So without wasting much of the time, I would want to hand over this speaking opportunity to Mr. Tulsi Krishna to take this forward from now. Mr. Krishna.
Thank you, Gurraj. Very good afternoon, all of you. In fact, in present scenario, the entire country, it has taken a lot of momentum and interest in the corporate world when once we come to know the issue of Tarun Tejpal. Probably you are all aware of it, how this Tarun Tejpal has got in this scam and how the things have taken shape, and now it happens to be within jail and is pillar to post is trying the legal matters. See, what I want to say is the corporate world in the working atmosphere, the responsibility of the employer is that he has to keep the working atmosphere, working infrastructure, it is free from the sexual harassment. Dear friends, I wanted to emphasize on this harassment. I tell you, even in the Constitution of India, it has been recognized. The Article 14, 50 and 91, 1G and 21 of the Constitution embodies very strongly about these rights of individuals and rights of this woman. And in order to understand the sexual harassment results in violation of the fundamental rights of a woman to equality under Article 14 and 15 of the Constitution of India. Those were the days when the people may not see much about if there is any disturbance or any harassment in the working atmospheres. But once we have been with the Constitution of India, under the Article 14 and 15 is mandatorily embodies the right to a woman that there should not be any harassment in the working place. And then nextly, our right to life and live with dignity under Article 21 of the Constitution. We need to understand that in any working atmosphere, if there is any chances of deviations in the treatment and the harassment, that even that go against to the Article 21 of the Constitution. And further, right to practice any profession or to carry on any occupation, trade or business which includes a right to a safe environment free from sexual harassment. So there friends, we all need to understand that when there is a practice, any profession, or to carry on any occupation, trade or business, that embodies the right to a safe environment free from sexual harassment. Further, the protection against sexual harassment and the right to work with dignity are universally recognized human rights by international conventions and instruments. Not only that, in India that we have recognized this protection against sexual harassment under the human rights, but also it has been borrowed with international convention instruments. And in this aspect, in order to touch you, in fact, the momentum on this sexual harassment in the workplace, it has started way back in the early 1970, 80 and 90. That we can come across in many of the Western countries, preferably in America and Singapore and some of the Asian countries also. And they have conducted many of the international conventions and instruments, and they laid down a lot of guidelines and principles. Accordingly, we also that we have given the right to the woman in the Constitution of India. See, this is a very important landmark, the case law in Indian Supreme Court. The case of Vishaka and others versus State of Rajasthan and others, the Honorable Supreme Court has laid down guidelines and norms to be observed to prevent sexual harassment of working women. In fact, this decision came out in the year 1997. The Honorable Supreme Court in the case of Vishaka and others in State of Rajasthan. I don't want to touch upon the facts of the case. In fact, the facts of the case of this decision is that one of the social workers in the remote village of Rajasthan alleged to be gang raped. The matter went up to Supreme Court, and in this judgment, the Supreme Court laid down the guidelines. The reason why is it the Honorable Supreme Court of India has felt that there is an apprehension, there is a kind of some sexual kind of harassment in the working atmosphere. So for that we need to bring in some course of law. In order to bring the course of law and in order to make an employer to be mandatory following some restrictions, some guidelines have been laid down. The first guideline in that decision is duty of the employer or other responsible persons in workplaces, other institutions to prevent or deter the commission of acts of sexual harassment. So now under this judgment and this decision, the Supreme Court of India has mandatorily put an obligation on the duty of the employer that it is a duty of the employer and also other responsible persons to prevent and deter the commission of acts of sexual harassment. Then nextly, they have to provide the procedure for the resolution, settlement or prosecution of acts of sexual harassment by taking all steps required. For this purpose, sexual harassment includes such unwelcome sexually determined behavior as the first thing is physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal and contact of sexual nature. So now, with this slide we need to understand this in detail. What is exactly the sexual harassment and what are the behaviors of sexual harassment and what are the effects of sexual harassment on others and what you should do if you experience sexual harassment. See, sexual harassment includes unwelcome sexual advances. Probably with this word itself we can understand unwelcome sexual advances. If any of the employee unwantedly or even unwelcomely, if they make any advances to other employee, preferably woman, that amounts to unwelcome sexual advances. Then request for sexual favors. Probably this kind of a request for sexual favors we come across day-to-day life also. And even Tarun Tejpal, the facts of the case, if you look into this in the media, this attracts this particular sentence, that is a request for sexual favors. Then other verbal or physical conduct of a sexual nature. Then all these aspects, that is unwelcome sexual advances, request for sexual favors, and other verbal and physical conduct of sexual nature that constitute is a sexual harassment. Now we are seeing this quid pro quo. That means to say that this for that. The quid pro quo is this. I can give you one example. If an employee is there, we need to understand this quid pro quo. So the meaning of this quid pro quo is this for that. So any one individual, any one employee, if they ask, see, you do me this favor, I will do this like. You do this favor, I can think of you about your reward. And if you do me like this, I can think of you putting you in some better placement, the transfer, something like this. This is what? This is give and take policy like. Give me this favor, I will help you out. And in the employment situation, based upon giving or not giving a sexual favor in the circumstances of failure to hire or promote, to hire or promote, or in the circumstances of awards, employment opportunities. All this will come within the definition clause of the quid pro quo. So if you don't give me, if you don't favor me this, I will not think of your hire or promote, or I will not give you any awards, or I will not give you any employment opportunities. This is what, if you give me this favor, I want to do like this. And other things are hostile work environment. That is to intimidate or to harass in terms of jokes, pictures, conversation, and other acts of a sexual nature. If any of the employee at the workplace, if I indulge in the acts of creating some jokes, showing some pictures, and making some conversation, and other acts of a sexual nature, the unwell will come, that is four ways: unwanted, unsolicited, offensive, and lawful. And if any of the employee in the workplace, if under any circumstances, if he has indulged in this kind of unwanted, unsolicited, offensive, and unlawful, then it amounts to the sexual harassment in the workplace. So now with this slide, we have to understand this. If there is any such acts is happen in the workplace, what is the role of employer, employee, the work environment? And next we'll have to see what to do if you experience sexual harassment. This is very important point to understand. When once you come across this kind of an acts in your workplace, so how you have to take up the issue, whom to contact, how to address this problem. So these are the ways we need to do it. The first thing is tell the person the behavior is unwanted. If once you come across any this kind of sexual harassment is happening in your working atmosphere, you need to categorically, you have to tell the person that the behavior is unwanted. Tell on his face that, dear mister, what you are doing is not correct. It's totally unwanted, unwelcome. Then unwelcome or unsolicited and to stop. So you need to categorically have to say that. Otherwise what will happen? Today a person is caught with some kind of a harassment. If we don't stop him in the beginning, in the first time itself, that may result that he may continue further life. That is the reason why you need to say at that moment itself that if you are not liking, if you are annoyed of this, if you are disturbed with the kind of a behavior of the other person, you may immediately have to say, this is totally unwelcome, unsolicited, please, dear mister, you please stop this one. Then, if this kind of a thing is not been stopped, this is further persist. The aggrieved, the harasser has to keep a record. Keep a record means not necessarily that you need to take a photo or need to write. Thing is this, when you once you feeling like this, other person is putting a sexual harassment, then try to make some record on that. Then ask co-workers if they observe the behavior and tell someone. That means to say that if any of the employee and any circumstances, the work spot, workplace, office, if you come across this kind of a unwelcome behavior, unsolicited acts, then immediately you have to tell that particular harasser that you need to stop, or otherwise you have to keep a record, or you will have to start this, you have to report to someone. In this aspect, all employees of the organization, they need to understand these are the following aspects. Anyone can experience sexual harassment. See, you need to understand here, not that a person next only experiencing sexual harassment, like no. If under any circumstances in the organizations, if this has not been stopped, or if we don't have the proper policy in this, and if we don't have a deterrent procedure policy, this kind of acts, this kind of things, harassment could happen to anyone. When this kind of any harassment is happening in the organizations, for that organization, institution, the establishment or the agency may be held responsible, mandatorily held responsible. Agency is liable for harassment by supervisors or managers. See, this kind of an harassment, we cannot generalize XYZ persons like. This may happen from any person, from the co-workers, from the supervisors, some managers, or the top brass also. That means to say that if any of the person is involved in this, this is totally a serious offense, serious act that has been recognized under the laws of our constitution and also under criminal law, and in all respects this has to be condemned. The next point is this: appropriate corrective action should be taken. Federal law prohibits retaliation. That means to say is, whenever an organization head or the organization institution comes to know that there is a kind of this sexual harassment happening within his office premises or at the workplace, then immediately the top of the institution, top of the organization, need to initiate appropriate corrective actions to be implemented. Nextly, whom should I contact if I experience sexual harassment? This is also important to know that whenever any of the individual, any worker in any work spot will come across this kind of harassment, immediately they need to report this incident, report this act to the immediate supervisor, boss or manager, or the head of the office, or human resource management service, or if in any organization you have any union official, you need to report to them, and Office of Resolution of Management and Special Emphasis Program Manager. All this what I wanted to say is, if any of the individual come across this kind of an act, immediately they need to report to the immediate supervisor, immediate boss like manager or head of the institution. See, when once it comes to the knowledge of the immediate boss, immediate manager, head of the organization, it is the duty of the employer or other responsible persons, the workplace or other institutions. That means to say, the immediate person, when once he comes to the knowledge of this something is happening in the organization, this kind of sexual harassment, you need to initiate some appropriate actions such as to prevent sexual harassment, to provide mechanisms for resolution of complaints. All women who draw a regular salary, receive an honorarium, or work in a voluntary capacity in the government, private sector, or unorganized sector come under purview of these guidelines. That means to say that any employees work for a regular salary or receive an honorarium, either in the government, private, and another sector, all these institutions come under purview of this. So now this is a very important aspect to understand. What is the complaint mechanism? See, any agreed woman may make a complaint of sexual harassment at the workplace, the internal complaint committee or local complaint committee. So any of the employee or agreed woman, if she come across this kind of a harassment, immediately they have to make a complaint to the internal complaint committee. That means to say that every institution, every organization, every establishment need to set up an internal complaint committee or local complaint committee in order to look into this kind of sexual harassment acts. So nextly, the internal complaint committee may, before initiating an inquiry at request of the agreed woman, take steps to settle the matter between her and the respondent through conciliation. So the second one is, what it contemplates is this: when we have a committee, when we have registered a complaint against any of the employee, immediately that committee jump into the action in such a way that they have to initiate an inquiry and immediately they have to summon both the agreed woman as well as the other person who was indulged in this. And they have to reconcile, they have to conciliate the matter, conciliate the act, conciliate the issue is concerned. Then a settlement has been arrived. The internal complaint committee or the local complaint committee shall record the settlement so arrived and forward the same to the employer or to the district officer to take an action as specified in the recommendation. This means to say that as the harassment appears to be very simple in nature, this internal complaint committee inquired about that incident and they have conciliated between this agreed woman and also other person. Then they have to make some kind of an arrangement or whatever the kind of an arrangement that has to be forward, that report has to forward to the employer, and not only the employer but also the designated district officer of the district. And nextly, an internal complaint committee or local complaint committee shall provide the copies of the settlement as recorded to the agreed woman and the respondent. That means to say, what this internal complaint committee has initiated an inquiry in this process, it has to put it on record everything and report has to be generated, and that whatever the report and settlement, that recorded copy has to be given to the both agreed woman and the respondent. As a settlement arrived, no further inquiry shall be conducted by the internal complaint committee or local complaint committee. This is a very important aspect. See, once any particular that sexual harassment complaint has been addressed, when once that committee has inquired and recorded a settlement, whatever that decision, it cannot reopen the case. That is the final like. That is the reason why whenever such complaints are coming to the committee, the committee has to look into the matter in depth and detail, and it has to hear both the aggrieved person as well as the other person, and it has to make a report, and that is the final one. Then the complaint procedure must be time bound. That's also very important to be understand this. See, I am the aggrieved person, aggrieved human. I have seen this because facing some kind of a sexual harassment in my workplace. I given the complaint to the committee. The committee cannot take its sweet time to address it. That means to say that whatever the complaint being lodged by aggrieved person, that has to be decided. The inquiry has to be conducted within the time bound. Then the confidentiality must be maintained. This is very, very important. This is very, very important, because in any organization or institution, if this kind of a things will come, they cannot make public to the entire all the employees like, because an individual complaint to be addressed individually, and individual report has to be generated, the copy to be given to both the parties, and confidentiality also to be maintained. Then complaints and witnesses should not experience victimization or discrimination during the process. That means to say this, if any aggrieved woman has given the complaint, after this inquiry and after this report, she cannot be victimized or she cannot be discriminated. This is a major thing that the law is protecting this aggrieved person. See, now the last slide I explained about the internal committee will be there. The committee will do the inquiry. The committee look into the grievance of both the parties and all that I have spoken. But now, in this slide, you need to understand how the inquiry procedure will be conducted. For the purpose of making an inquiry, the internal complaint committee or local complaint committee shall have the same powers as are vested in a civil code under the Code of Civil Procedure. This is very, very important. You need to understand this. See, if any committee we have formulated in the organization, we have created in the institution, but that committee don't have the proper powers. If there is no delegation of the authority, then the committee cannot function like as a judicially or non-judicially. That is the reason why this committee have the powers as good as the civil court of law. That means to say, summoning and enforcing the attendance of any person and examining him on board. Say this is very, very important. The aggrieved person gives the complaint, and the committee members, if they do not have the powers to summon or enforce the attendance of any person, then the purpose of the committee will be diminished. That is the reason why the committee has been embodied and delegated with the powers of a civil code, while summoning and enforcing the attendance of any person and examining him on board. Secondly, requiring the discovery and production of documents, and this committee can look into any kind of a document, and it could summon the document from either of the parties. And next, any other matter which may be prescribed. That means to say that while conciliating this matter, when the committee comes to the conclusion that we need to summon, we need to enforce the attendance, that can do it. And if it wants to summon any of the documents related to this commission of an act of sexual harassment, that can summon the documents. And any other things that which may relate to this inquiry, they can do this, they have the power. And lastly, the inquiry should be completed within a period of 90 days. This is the mandatory. That means to say, whenever a committee registers the complaint, and that complaint has to be initiated within reasonable time, but they have to complete the entire process, modus operandi, within 90 days. Then I will come to inquiry procedure. On the completion of inquiry, the internal complaint committee or local complaint committee shall provide report of its findings to the employer or the district officer within a period of 10 days from the date of completion of inquiry, and such report be made available to the concerned parties. See, this is also mandatory to the committee, that whichever the committee that completed this process, that is the internal complaint committee which completed the process, that has to give and submit the report, the findings to the employer. This is an important aspect. The committee has initiated all this procedure and it has adjudicated this issue and it has given its findings. If that findings not been given to the employer for further action, then entire the process of this, the inquiry will be no justification. That is the reason why the internal committee, after completion of all this process, it has to submit the report to the employer, the management, top management, for the further initiation of the action. Secondly, the internal complaint committee arrives at the conclusion that the allegation against the respondent has not been proved. It shall recommend to the employer, district officer, that no action is required to be taken in the matter. See, you all notice here, if any of the complaint has been lodged by any of the aggrieved person or woman saying that there is a sexual harassment in my workplace or an establishment, after adjudication or after inquiry, once the internal committee comes to the conclusion that this has no substance in allegation, there is no truth in this, even they have to give that report to the employer, and also they have to recommend to the employer saying that no, in this complaint there is no substance, there is no truth, thereby the inquiry has to be dropped. Further, the internal complaint committee arrives at the conclusion that the allegation against the respondent has been proved. It shall recommend to the employer, district officer, as the case may be. That means to say, when once in the committee that the complaint has been upheld or it has proved beyond reasonable doubt after the inquiry, then it has to recommend to the employer or the management and also the district officer to take an action for sexual harassment as a misconduct in accordance with the provision of the service rules applicable to the respondent. Yes, when once this act is proved, then it has to recommend to the management to initiate action against the harasser or the respondent. Secondly, to deduct, notwithstanding anything in the service rules applicable to the respondent from the salary or wages of the respondent, such as it may consider appropriate to be paid to the aggrieved person. There are two things. One is that after the inquiry report, it has to recommend to the employer, the management, to initiate an action for sexual harassment. Secondly, even it can go to the extent that it can deduct, notwithstanding anything in the service rules applicable to the respondent from the salary or wages of the respondent, such as it may consider appropriate to be paid to the aggrieved person. All workplaces should have an appropriate complaints mechanism with a complaints committee, special counselor, or other support services. See, all these 2-3 slides we have just discussed about the complaint mechanism, and when once the complaint has been lodged, the internal complaint committee, how they have to go, how they have to initiate inquiry, how they have to give the report, and after once this report has been generated, and whom to submit the report, and with that report what are the actions to need to be initiated, all that we discussed. Now this is the important area where overall the people that they can sit in the internal complaints committee. This is very, very important aspect we need to understand on this. The internal complaints committee shall consist of the following members to be nominated by the employer, that is the management. The first member is this the presiding officer or a chairman who shall be a woman employed at a senior level at workplace from among the employees. This is very, very pertinent to understand this. See, every management, institution, organization, they have to create in the establishment the internal complaints committee, and that committee has to be headed by one that is a presiding officer or the chairman, that a woman shall be a senior employee of the organization, and next, not less than 2 members from among its employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. Once the committee has been formed, as I told you that presiding officer chairmen to be appointed. In addition to that, you need to appoint another 2 members among women where they need to have a knowledge of the social work, or otherwise they need to understand all this agony or this acts of sexual harassment. That means to say that they should have a thorough knowledge, because they should be in a capacity to register these complaints, they have to inquiry these issues, and they should be in a capable to give the report to the management. That is the reason why they need to have a proper knowledge on this. Nextly, 1 member from amongst non-government organization, NGO or associations committed to the cause of women, or a person familiar with the issues relating to sexual harassment. So, we need to understand in this internal complaint committee, we need to have one presiding officer or a chairman, or 2 other women members, and also an external member from any non-NGO. That means to say that the very purpose of this is this internal complaints committee has to adjudicate as that of a quasi-judicial in nature. This committee should have all the powers as that of a civil court. This committee should have an examine and inquiry in depth, and in order to give justice to the aggrieved person. A presiding officer and every member of the internal committee shall hold office for such period not exceeding 3 years. This is also important. In any organization, a person has been appointed as chairman or the member, they can't be stay there up to their retirement. That is the reason why here it embodies and contemplates that all these members and presiding officer, their term of period is 3 years. Then the next point is local complaints committee. The appropriate government may notify a district magistrate or additional district magistrate or the collector or deputy collector as a district officer for every district to exercise powers and discharge functions. See, as I told you, we comprise the committee, we form the committee within the establishment with the presiding officer and 2 members and 1 NGO. But this local complaints committee is a duty of the government. It's a duty of the state government that in each district it has to appoint a district collector as the appropriate authority under this act to look into this kind of matters. So every district officer shall constitute the district consent a committee to be known as local complaints committee to receive complaints of sexual harassment from establishment where the internal complaints committee has not constituted due to having less than 10 workers or the complaint is against the employer himself. See, this is a very important you need to understand. Let's not confuse on this also. Because every organization, we have our own internal complaints committee. That's the one thing. And there are establishments where they do not have the internal complaints committee. And under that circumstances, the government will make a district collector as a district officer, and they make district officers a local complaints committee. And wherever any establishment do not have the internal committee, they can lodge the complaint. They can register the case, the sexual harassment under this authority. And if any cases that this kind of a sexual harassment is happened by employer himself, that is the head of the institution, head of the organization itself, it has been happened, and for any aggrieved person they don't have a confidence on their own internal local committee, then they can approach this local complaints committee. Then coming to this, where such conduct amounts to a specific offence under the Indian Penal Code or under any other law. See, all this time we have just discussed about if there is any sexual harassment in the work spot, is a condemnable, and we are not supposed to encourage this kind of an acts in the workplace. For that, we need to initiate kind of an inquiry with the internal committee. But while doing this kind of a sexual harassment, if any of the act committed by the harasser or the respondent, if it attracts any provisions of the criminal law, if it attracts any criminal, say for example, in a workplace, if any of the individual, while doing a sexual harassment, if the aggrieved woman suffers any major injury, when once a major injury is she suffered, then it attracts a criminal provisions of law of the country. That is the reason why when this kind of a things happens, immediately the employer shall initiate appropriate action in accordance with law by making a complaint with the appropriate authority. Because if any of the acts by any of the individuals which attracts criminal law, then the criminal jurisprudence come into picture. That is the reason why immediately the employer has to initiate appropriate action. That means to say that he has to lodge a complaint with the jurisdiction police. And nextly, it should ensure that victims or witnesses are not victimized or discriminated against while dealing with complaints of sexual harassment. So when any act of an individual, if it attracts criminal, then that proceedings has to be initiated. And if under any circumstance that if any person, the victim or the witness are victimized with this, there shall not be any discriminated. Then nextly, the victims of sexual harassment should have the option to seek transfer of the perpetrator or their own transfer. That means to say that a right has been created to the person who has suffered this kind of an incident, and if any other person has suffered this kind of the sexual harassment, they could very well can go or request the employer that they can seek the transfer on their own, or they can request for the perpetrator to transfer to the establishment. See, one thing we need to understand is, all this time we have understood what is sexual harassment, what are the acts coming to sexual harassment, and what are the mechanism for this. Now we have come here this one with the preventive steps. See, the preventing area, every organization and institution, they have to take care. Sexual harassment should be affirmatively discussed at workers' meetings, employer-employee meetings. This is very, very important case. Every organization, they need to have the policy on prevention of sexual harassment. Not only you just a label, or if you notified in the notice board just a policy and the organization, but you need to give a strong awareness among the employees. That kind of an awareness, that kind of a knowledge, you can develop in the workers' meetings and also employer-employee meetings. Then guidelines should be prominently displayed to create awareness of the rights of female employees. So as I told you, the guideline, the policy and the sexual harassment, it should be prominently displayed, wherein all the employees will look into this and understand their rights whenever there is an act of this sexual harassment. The employer should assist persons affected in cases of sexual harassment by outsiders. All this time we have just discussed about any harassment within the workplace, within the employees of the organization. But whenever there is an harassment from the outsider also, then the employer or head of the organization, they have to help the affected employees. Then central and state government must adapt measures including legislation to ensure that private employers also observe guidelines. That means to say that time and again, whenever the state government, the central government brought in any amendment, brought in any act, any rules and regulation, this has to be mandatorily followed and adopted by all the employers of the organizations. The names and contact numbers of members of the complaint committee must be prominently displayed. That means to say this, we are all understood about the internal complaints committee, and whatever the internal complaints committee members will come, all their names and address has to be displayed. Then we comes to employer responsibility. This is very, very, very important. Recognize sexual harassment as a serious offense. So it is a duty of the employer, duty of the management, that whenever this kind of any act come across in the organization, that we cannot excuse these harassers or the people who involve this kind of an act, but immediately what you need to do is recognize it. Sexual harassment is a serious offense. Recognize the responsibility of the company, establishment, factory, workplace to prevent and deal with sexual harassment in the workplace, and recognize the liability of the company for sexual harassment by the employees or management. That means to say that this kind of an act shall not be, under any circumstance, shall not be encouraged. This has to be very with the iron hand, with the deterrent, that it has to be stopped, and the employer has to initiate all necessary actions and also the system for that to not to happen, the sexual harassment. Then the employer is formulate an anti-sexual harassment policy. They should include a clear statement of the employer's commitment to a workplace free of unlawful discrimination and harassment. As I told you that an employer has to display or notify a sexual harassment policy, but in that this has to be very clear. The mandatorily has to make an averment. That is, clear statement of the employer's commitment to a workplace free of unlawful discrimination and harassment, clear definition of sexual harassment and prohibition of such behavior as an offense, constitution of a complaints committee to investigate, mediate, counsel and resolve cases of sexual harassment. It is thus imperative that the committee must consist of persons who are sensitive and open to the issues faced by women. A statement that anyone found guilty of harassment after investigation is subject to disciplinary action. That means to say is, employer, while notifying this sexual harassment policy, he has to take care of all these points and he has to mention all these clauses. And nextly, the range of penalties that the complaints committee can levy against the offender. Then explicit protection of the confidentiality of the victim of harassment and of witnesses. A guarantee that neither complainant nor witnesses will be subjected to retaliation. Publish the policy and make copies available at the workplace. Discuss the policy with all new recruits and existing employees. Third-party suppliers and clients should also be aware of the policy. Conduct periodic training for all employees with active involvement of the complaints committee. So this is very, very important. The duty of the employer is this: just by notifying the report will not be suffice, but he has to ensure that the things will be materialized in this establishment. Then next is punishments of false or malicious complaint and false evidence. All this time, we have just discussed that whenever there is a kind of any acts of sexual harassment, what is the process, what is the procedure, all that. And now we need to understand that if that sexual harassment, if anybody has alleged that has given the law the complaint, if it is a malicious, then what is the recourse to the open to the other person is, that we need to understand here. The committee arrives at a conclusion that the allegation against the respondent is false and malicious. The aggrieved woman or any other person making the complaint has produced any forged or misleading documents. So once this inquiry committee comes to know that the aggrieved woman that she has given malicious complaint, a false complaint, and that has been confirmed in this report of the committee that a false complaint has been lodged, then definitely even to that the woman will need to initiate an action on that the committee has to recommend for to initiate action on that lady also. The mere inability to substantial complaint or provide inadequate proof will not attract action against the complainant. That means to say that just mere allegation, mere register will not be sufficient, that they have to be proved in an inquiry behind reasonable doubt. Further, the malicious intent or falsehood on the part of the complainant shall be established after an inquiry in accordance with the procedure prescribed before any action is recommended. Even though this, if you want to conclude that there is a malicious complaint, that has to be proved in the committee. The committee, once all the members comes to the opinion that this complaint is a very false and malicious, then immediately that committee can recommend to the employer that even against that woman also can initiate an action. Further, the procedure applies to those who have appeared as witness before the committee. This is not only the people who have given the complaint, but also the witnesses given the anybody witnesses who have supported the malicious complaint, they also can be punished. Then determination of the compensation. For the purpose of determining the compensation to be paid to the agreed woman, the committee will have regard to the mental trauma, pain, suffering, and emotional distress caused to the agreed woman. That means to say this committee, internal complaints committee, they have the power, they have the right to determine the compensation payable to the agreed woman. If whenever in that kind of circumstances, what amount of compensation to be awarded is the question. That circumstances, the committee, they have to look into the mental trauma, pain, suffering, and emotional distress, and all these agonies they have to be looked into this. They have to consider accordingly. They have to determine the compensation. Then the loss of the career opportunity due to the incident of sexual harassment. They also look in if there is any loss in the career opportunity to the agreed woman. So based on that, they have to decide the compensation. Then medical expenses incurred by the victim for physical or treatment, the income and financial status of the respondent, feasibility of such payment in lump sum or installment. That means to say that the internal complaints committee, they have the power, they have been delegated not only interrogate, inquiry the allegations of sexual harassment, but also they have the power to determine to impose a compensation to the agreed woman, but only after considering the mental trauma, pain, suffering, emotional distress, and also the loss of the career opportunity, and also if there is any medical expenses incurred, and also they have to look and consider the financial income status of the respondent. Then prohibition of publication or making known contents of complaints and inquiry proceedings. This is very important. The recommendation of the committee and the action taken by the employer should not be published, communicated, or made known to the public, press, media in any manner. The prohibition is applicable to others who are dealing with the complaint. See, whatever the report that given by the internal complaints committee, as I told you that the report copies also being shared with the agreed woman also respondent. Even with this, but however, these findings in the report should not be shared by public or the press or media. That means to say that all the adjudication of this kind of an act, the confidentiality has to be maintained, both by the person's agreed person, respondent, and also the management. Then there is a provision for the appeal. Any person aggrieved by the recommendation of the committee or the action taken by the employer may prefer appeal as per the provision of the service rules. See, we need to understand on this, because appeal means, as on now we understood that there is a committee, the committee can have the power and everything. But many a times, even the committee also may go wrong. There may be circumstances. See, if the agreed woman or the respondent has not been happy with the report of their findings of the internal committee, then there is a provision. With that, according to that provision, they can go on appeal and they can question the validity of the report also. Lastly, I come across the duties of the employer. Every employer shall provide a safe working environment at the workplace, which shall include safety from the persons coming to contact with the workplace. See, this is a constitutional binding, constitutional obligation. This is the mandatory, the duty of the employer, that he has to provide the safe working environment to all the employees in the workplace. Then display the order constituting the internal complaints committee at any conspicuous place in the workplace. That is, there is also a mandatory provision that the employer has to undertake that he has to display, he has to notify the internal complaints committee in the notice board. Undertake workshops and training programs at regular intervals for sensitizing the employees regarding the provisions of the legislation. This is in order to give more awareness, in order to give more knowledge to all the employees that in order to avoid this kind of a sexual harassment should not happen in the workplace, the employer has to create an atmosphere in such a way that he has to undertake all workshops, training programs at regular intervals, making all employees to attend and participate in those programs. Then provide assistance to the woman if she so chooses to file a complaint in relation to the offence under IPC or any other law for the time being in force. As I told you, if there is the complaints of sexual harassment where within the committee they can adjudicate, but some of the circumstances where this acts of sexual harassment which had resulted in the IPC, which attract the IPC, then the employer has to give an assistance to the aggrieved employee to approach the courts of law. Then freedom from sexual harassment is a condition of work that the employee is entitled to expect. This is, we all accept that freedom from sexual harassment is a condition of work that an employee is entitled to expect. This is where the employer obligation, employer liability, that he has to create an atmosphere free from sexual harassment. Then other relevant provisions, just I go through this. District office shall monitor a timely submissions of report furnished by the internal committee and take such measures as may be necessary for engaging non-governmental organizations for creations of awareness on sexual harassment and the rights of the woman. See, even as I told you, the district officer or the designated collector, you also have the delegation of authority from the government that you also can intervene in this kind of a internal committee, and you also give the guidelines to the management. Then secondly, the internal committee should in each calendar year prepare an annual report and submit the same to the employer and the district officer. That means to say that, so whatever the list of the internal committee that adjudicated, they have to give a information to the district officer. The employer shall include in its annual reports the number of cases filed, if any, and the disposable in the annual report of the organization. Appropriately, government should monitor the implementation of the Act and maintain data on the number of cases filed and disposed of in respect of all cases of sexual harassment at workplace. The appropriate government is empowered to call for information and special record. See, this relevant provision is that in order to have an accountability, that when any establishment this kind of sexual harassment is happened, the cases are how it is adjudicated, how it is disposed of. In order to have an accountability, this district officer has got the power that he can coordinate with the concerned management and the establishment that he can get all the reports of those inquiries. And penalty for non-compliance. So this is also very important in me to understand this. Bill provides that where the employer fails to constitute an internal complaint committee, take an action under section 13, 14, 22, contravenes or attempts or contravene and abets contravention of other provisions of this act or any rules made thereunder, it shall be punishable with fine which may extend to rupees 50,000. For repeat violation, higher penalty has been provided. Every offence under this act is non-cognizable. See, the penalty clause is very important, and now this is very important to share with all of you that, as I told you this, the Supreme Court of India, the case of Vishaka and others, it has given the direction to all the central government, state government, saying that you need to create a committee, internal complaints committee in the establishment. You have to give a opportunity to look into the matter to adjudicate the sexual harassment. But however, our central government, government of India, in the year 2013, April 22nd, it has passed this bill. The bill name is called the Sexual Harassment of Women at Workplace. That is Prevention, Prohibition and Redressal Act of 2013, placed before the Parliament, and it has got an assent of the President, and it has come into effect across India with effect from 22nd April 2013. Now, all organizations, all managements, all corporates, is a mandatory that in their workplace they need to create this internal complaints committee, and they have to adhere and comply as the clauses embodied in this, that is the Sexual Harassment and Women's Workplace Act of 2013. So by virtue of this bill, if there is any contravention by the employer, then it amounts to a criminal offence, and even employer or the management in the organization, they can be punishable with fine which may exceed to 50,000 rupees the first time, and for the repeat violation, the higher penalty can also be imposed. Why is the punishment which might have been imposed in the first conviction subject to the punishment being a maximum provided for the same offence? However, in case a higher punishment is prescribed under any other law for the time being in force for the offence for which the accused is being prosecuted, the court shall take due cognizance of the same while awarding the punishment. Cancellation of his license or withdrawal or non-renewal or approval or cancellation of the registration, as the case may be, by the government or local authority required for carrying on his business or activity. So by virtue of this bill of 2013, the sexual harassment of women at workplace, if the management are not complied, then they can, for the first time they can impose 50,000 rupees, second time they can impose twice the punishment, and even further if the management not adhere to the clauses of this act, the bill, then they could very well, they can cancel this license or withdrawal the registration also. Dear friends, with this I conclude regarding the sexual harassment of women at workplace. Then in case any of you have any question on this, you can type it.
Hello everyone. I hope all of you would have really got to know more information about this act, that is sexual harassment at workplace. We have been from Paybooks perspective, we thought it is not only the from the solution perspective, it is not only giving a solution on the payroll, but we also thought our esteemed clients and others need to know more about other areas associated with the payroll, because it can be on employees, it is again definitely on many of the employees working, and employers may have have to know about many of these responsibilities. In this connection, Mr. Tulsi Krishna helps a lot of our clients in maintaining labor law and statutory compliance. And in this regard, we requested him to come and deliver a webinar on sexual harassment. I hope all of you have enjoyed and understood about the entire subject on sexual harassment. If you have any questions on this, please. There are two options. One option is you can even type a question right away on the chat box so that Mr. Tulsi Krishna can address it immediately. Or You also have an option to go and send an email directly so that you can give help. If you have, you see right now you may not have any so that email in future you can go on answer people's questions at any point of time. Whenever you send out an email to him, and Mr. Tulsi Krishna also will be available to help any of you, on your organization's
to a lady if she is sexually harassing one more lady.
I will now hand over this to Mr. Tulsi Krishna
If a lady
to address all the questions being received so far.
One more lady will be out of line.
Here there is a one question. If one lady sexually harasses another lady, would this act apply? The act applies very much.
Client has 10 group companies. Single group but 10 different legal entities. Should they have different policies or one committee or multiple committees?
See, there is a one question saying that one group are having 10
Legal entities.
legal entity in different places, different registration.
Different registration.
Different registration. If that is the case, each entity is a different registration. They need to have their own internal compliance committee, and also they have to notify the sexual harassment policy. Next question.
One company has put its employees in one more company, staffing basis. There they are experiencing sexual harassment. How should this company go about handling that? Company A employees are placed in company B as part of staffing. In company B they are experiencing sexual harassment. What should company A do?
Company A has to lodge a complaint, register a complaint in that company.
No, you should answer. Tell the question first.
Yeah. A has been deputed.
Company A has employees.
Has employed
Employees in and staff employees in company B.
One company A has employees
In company B
in company B
as part of staffing.
as part of staff.
Or contract management.
Staff. There is another question that company A is employed in company B as a part staffing. If a company A is undergone any this kind of a things where it come across this kind of a sexual harassment, they have to register the complaint with that company, and that company where they have the internal the complaints committee, they have to adjudicate this matter.
Is proof of sexual harassment handled?
There is one question. Is there any proof of sexual harassment mandatory to lodge a complaint? No, because in many times this sexual harassment is such a way that even without having a practical proof also it amounts to a sexual harassment. That is the reason why the internal committee is constituted. That internal committee should have a appropriate knowledge on this to adjudicate this kind of a cases, and they have to study these circumstantial facts of the case, and based on that they have to give a report on this. That's the reason why I say that there will not be any proof, but circumstantial, whatever the allegation and how this agreed woman and agreed person witnesses, how they give the facts and evidence, based on that the conclusion that the committee has to give the report.
Under which section can we register the complaint?
Again, this.
The aggrieved woman need not mention any of the section that according to the bill, even just in a petition, they can narrate what has they really undergone, what is the problem they face, what kind of sexual harassment in their workplace has happened. With that petition only they can reach to the internal committee.
Sir, question go to Jara again. We have 10 women employees.
There is a question, we have 10 women employees, out of which 3 are contract employees and 1 is temporary and
so committee has to be formed out.
we have 10 women, we have 10 women employees, out of which 3 are contract employees and 1 is temporary. So committee has to be formed or no? See, here you cannot have a discrimination of the permanent employees or staffing employees or contract employees. So you need to have a form an internal compliance committee.
But I mean, in the committee, one NGO person is required. If we are not able to...
There is a question, what if the company has laid out the policy but unable to deploy the representative from NGO? See, all these years, the authority will not come into interfere in this, but by virtue of this bill passed in 2013, that is the sexual harassment of women workplace, and enacted in 22nd April 2013, is a mandatory to have an NGO. The very purpose of this act, very purpose that to have an NGO is that an NGO can inquire the matters in an impartial manner and they are aware of all this kind of a sexual harassment. That's the reason why they have complied. If a female employee is complained about a sexual harassment incident internally but is not satisfied with the action against the perpetrator, if she wants to address the again after a considerable time has elapsed, is it possible? No. This is what I told you while addressing the matter. When once the complaint has been lodged, internal committee has looked into this and it has been adjudicated, it has given the finding, then and after that they cannot have the question once again.
Now, what if she experiences harassment once again?
If she experiences once again, then definitely one more complaint she can lodge, no issue. For one complaint, one adjudication, one report, that is the finality.
But she can go on appeal.
That the provision is there.
Also, in the cases of the sexual harassment of third party.
There are 2 people, one lady, one guy. They are exchanging sexual favors. I come to know. Can I lodge a complaint?
Yes.
People should ask the question.
There is a one question that one lady and one male, they have an
Exchanging sexual
sexual favor, exchanging sexual favor. Would the third party
be able to complain?
Would the third party can complain against the sexual favor of the 2 individuals? Definitely, very much. They can give a complaint.
Right.
Almost done.
Dear members, you have any more questions? I would most welcome.
Is it mandatory to have a proof of sexual harassment? What is the proof? There is no proof.
Well, I have done today.
There is no proof required. Simple.
There is a one question from my dear member. What is the proof? See, in a working place, when woman and male is working, the male person has showing some signs to show that when you come in the evening, like something he is showing in the fingers, in the face and the expression and all that. So here to substantiate the proof is very difficult. But however, the woman has to say that in the petition they have to mention, say she can very well, she can mention the person who has did like this, time she can mention and what circumstances. See, under all these facts of the case, that is the reason why the learned committee look in into the entire facts of the case, and I will give the findings on that. Any more questions? And further, dear members, as I told you that while discussing with you that you all need to notify the sexual harassment policy in your notice board. That policy I will send it, shared with you, share all the members.
I think we started our webinar series from last month onwards. I think the first of its kind was on the benefits, how to save tax. That was the first of the series which we started in the last month, and very soon we will have those recording in our website. Similarly, we will have this session, this webinar also be available in our website, and also we'll notify all of you as soon as we have the webinar in our website, on our website. So with this, we would like to thank you, all of you, for sparing your time, your valuable time, and coming and be part of this webinar. So nice of you, and we would also intimate you all the way, like every month Paybooks would like to conduct a webinar. Certainly not only on Paybooks or on the payroll perspective, but which would help our finance and HR functions of any organization, whatever the topics which are very helpful. So we have in mind, like on statutory compliance, we have something again coming on the tax perspective, again on the what best compensation structure an organization should have so that an employee can take more take home salary and be very satisfied while working at an organization. So all these are coming in the coming months. Please keep looking into your emails on from Paybooks perspective. And with this, I would like to ask all of you to give your valuable feedback on this webinar, which helps us to improve if there are any findings, and also give our coming webinars can be more helpful to all of our audience.
There is one question: how do we know or contact our district officer? Normally, it is a district collector.
I think there is one more question. Looks like it is not answered. I will give to Tulsi Krishna. With this, after this question, we would like to end this webinar. Thank you all for participating in this, and have a nice evening.
There is one question from Ansur Rai Chaudhary. How do we know or contact our district officer? See, normally this is the lookout of the government authorities. Normally the state government in each district, its district deputy commissioner, district collector has been made the district officer for this. And for us as a management, we need not know anything like who are the person, district officer, district collector. No, for him, if any such things is complaint to be lodgeable, we have to do it. Otherwise, not necessary.
Or the cost can sexual harassment or answer.
No, how far it agita? One incident came 2 years back. Can I report it now?
There is one question: how far in the past can a sexual harassment incident be reported? I didn't get you this question. How far in the past can a sexual harassment incident be reported? How old?
So there was an incident 2 years back.
Yeah.
Lady, can I come now and complain to the? Yes.
What is his name? His name is
Chaudhary.
Ms. Chaudhary. Whenever this sexual harassment cases will come across, no, you cannot report after 2 years or 1 year, 6 months. Whenever any aggrieved persons will come across on that, immediately they have to report. At least some reasonable time, I can say always. Reasonable time is this, in order to make up our mind and to report to the committee like 1 day, 2 days, 3 days, or 1 week or 15 days. That is a reasonable time normally we call. But they cannot report after the months together or years together. It is not possible. Any more questions, sir?
Yeah, this was answered, I think, right? In one of our company, we have 3 women girls there. Employees, as per that, we don't fall under from the internal committee. And the authority of forming the local complaint committee. I think it has been answered. Okay. Thank you.
Thank you. So thank you very much.